Welcome to the Virtual Spring Meeting 2020, brought to you by the American Bar Association Antitrust Law Section. The Spring Meeting is the section's premier event, a multi-day celebration of learning and camaraderie. The Virtual Spring Meeting brings together the world's leading experts on competition, consumer protection, and privacy law, discussing the most compelling issues of the day. Enjoy the show.
Hi, and welcome once again to the Virtual Spring Meeting. My name is John Roberti, and today we're presenting yet another great panel. It is Briefing with the State Enforcers. The panel is sponsored by the State Enforcement Committee and the Consumer Protection Committee. With me today to provide some context for the program is Liz Brady. Liz is the Chief of the Multi-State Antitrust Enforcement at the Florida Office of the Attorney General. Liz is also the co-chair of the State Enforcement Committee. Hi, Liz.
Hi, good afternoon.
So, Liz, what are we doing today?
Well, today we have a panel with the state enforcers, and we're going to be talking about recent developments and areas of focus, as well as initiatives in the state antitrust and consumer protection area. Now, I'm hoping that our panelists will also touch on the current state of the state and federal relationship. As I'm sure many of our audience knows, there's been some question as to how the states and their federal counterparts are getting along. And I really hope that our panelists get to that today.
Very interesting stuff, very timely. Maybe you can tell us a little bit more, but why is this relevant, important?
Well, I think it's obvious to anyone who turns on the TV these days that federalism is the topic of the day. Indeed, anyone who has watched the news over the past year and pays any attention to antitrust knows that the states have been very active. They've had a 60 Minutes piece talking about a very large nationwide price-fixing lawsuit focusing on the generic drugs. And as everyone knows, there was a little merger challenge involving the states or some of the states, when others of the states and the federal government had actually settled that same lawsuit. Then there was a big announcement of an initiative of looking into big tech platforms. Therefore, it's even more important these days for antitrust and practitioners to be aware of and pay attention to what's going on with state enforcement. And if you're not aware, you certainly bear a risk.
Yeah, interesting, very timely, and you're right. It's the top of the news all the time. What do you think we're going to learn today?
Well, I hope to learn whether the current COVID-19 crisis has had any impact on state enforcement. Has it changed their focus? And has it presented challenges which might be slowing down their ability to bring effectively their cases? I also like to know, as I alluded to previously, whether the seeming rift between the state and federal enforcers, which was highlighted by the Sprint T-Mobile litigation, is going to decrease antitrust enforcement in both the state and federal arena. And finally, are there any areas of particular focus or interest that practitioners need to pay particular attention to going forward in order to be fully informed as to where the next cases are going to be?
All right, important stuff. Liz, will you stick around and let's watch the panel together, and then maybe we can come back in the end and we can talk a little bit about some of your takeaways. Would that be okay?
Oh, perfect. I can't wait to see it.
Great. Okay. With that, let's send it down to the moderator, Bill MacLeod, and get started. Bill, the floor is yours.
Hello, I am Bill MacLeod. This is Briefing with the State Enforcers. Today, we have Assistant Attorneys General, Deputy Attorneys General from around the country, and I'd like to introduce my panel and then get right into the priorities that the states are bringing to antitrust and consumer protection law enforcement. The session chair for our panel today is Gwendolyn COOLEY, the Assistant Attorney General from the Office of the Attorney General Madison, Wisconsin for the state of Wisconsin. On our panel, we also have Paula BLIZZARD, the Deputy Attorney General, the Office of the Attorney General in San Francisco, California. Stacie LAMBERT DEBLIEUX, the Assistant Attorney General, Office of the Attorney General in Baton Rouge, Louisiana. And Kathleen KONOPKA, the Deputy Attorney General from the Office of the Attorney General of the District of Columbia, Washington, D.C. Let me start with each of you in the order, starting with our session chair. Gwendolyn, I would like to go to you and ask you what is hot and on the top of the priorities for the Wisconsin antitrust enforcement.
So one of the things that we have been working on for years, and we continue to work on, are drug cases. I think in light of what has been going on with COVID, I think that these kinds of drug cases are going to be as important as ever. So I think you'll continue to see developments for the state of Wisconsin and for many other states on drug and hospital healthcare related cases. The technology cases that were, those investigations that were announced last fall, those will continue to be big. But one of the things that my office is working on that I am not personally working on because it's consumer protection is prosecuting price gouging related to anything related to COVID, N95 masks, things like that. We are on top of that and making sure that that is not happening in the state of Wisconsin.
Those cases, I suspect, are going to be coming hot and heavy over the next several months. We're looking forward to seeing more of those developments. Let me turn to Paula in California. And Paula, just for the beginning, can you tell us what is on your desk and what is really hot in your office right now?
Well, hello, everyone. What is on my desk? Well, I'm at home, so like a bunch of crap and stuff that would not be on my desk in the office. As everyone can tell from the video, we're all at home, obviously. So work-wise, what's on my desk? We just finished the Sutter T-Mobile case, or we've almost finished it. We have healthcare matters. We're involved in many of the drug cases, and we're continuing many other investigations which have been topics that have come up repeatedly. So gas pricing is always an issue in California. I know that we are not part of the large multi-state looking at tech cases. I will just say about that all that means is we weren't in the press release, and you can take from that what you will. And we're continuing to look at mergers. I'll also say, as Gwendolyn did, and especially in California, we have a very large consumer protection section. We obviously have a very large law enforcement group. The Attorney General just did some raids in Oakland 2 days ago to seize a bunch of masks and hand sanitizer. And again, the price gouging for COVID-19 is a hot topic, and we are bringing all available resources to bear on that. So that is definitely an immediate focus of the Attorney General writ large.
We're very similar to the issues that Gwendolyn and Paula already touched on. We've continued to move forward with the pharmaceutical cases and the tech company cases as well. Our consumer side, which is in the same division I'm in, but I don't work directly on that, are very involved in price fixing and price gouging cases. One of the things that we've learned too recently is that US DOJ is very interested in, and the FTC in coordinating with our offices. If we do find that there are price gouging cases that may be anti-competitive or rooted in anti-competitive behavior or helping to further anti-competitive behavior. So that's one way that the antitrust side and the consumer side will be working together a little bit moving forward, is to try to keep our eyes open and identify if there are any price gouging complaints or cases of that nature that may be sound in antitrust or helping to further an anti-competitive scheme. So.
Well, let's come all the way back to the scene of the real spring meeting when we are not virtual. And let me ask Kate, what is happening in the District of Columbia, and what should we be looking for while you are enforcing from at home?
Yes, hi everyone. So the district has remained very active. We're obviously all working from home and being as safe as possible, but we've remained very active in these spaces. We are also very active in the drug cases and the tech cases, but we also have a very important focus to our antitrust practice in terms of the intersection of labor and antitrust. And so we've been looking very closely in terms of that. We've actually found this to be a very fruitful place for local antitrust enforcement in terms of looking at non-competes in local businesses that adversely affect our workforce, particularly our low-income workers in the District of Columbia. On the consumer protection front, we have also been very active in price gouging. We have a very strong price gouging law that went into effect and was triggered as soon as a state of emergency was declared. And we have been very active in ferreting that out. We've had dozens of complaints, and we actually have already issued more than 15 cease and desist letters to local businesses and also to landlords, because we also construe that the price gouging also applies to undue increases in rent during this period. We also have been working with our sister states in the multi-state context to address large national retailers, and have had numerous conversations with large retailers, including Amazon and Walmart, in order to make sure that they are properly policing their platforms in terms of price gouging.
Fascinating. Well, let me pick up on the labor antitrust intersection again. What kinds of cases are you seeing, or at least what sorts of issues do you think the public and the bar ought to be sensitive to in this new area of increasing antitrust enforcement?
Yeah, so what we have been looking at largely are non-competes and no-hire agreements in terms of the workforce. We actually led 2 comments with in the multi-state context to the FTC on these issues. And we now are looking largely at local enforcement. We have ferreted out a couple of different businesses that we are currently investigating for really substantial non-competes that are very broad in terms of both time and geography, that really do hamper the ability of particularly low-income workers to find employment. And we have found that it's particularly the case in during the current time when employment is obviously so difficult and scarce. We recently did have success in impressing to release all of their laid-off employees from a very egregious and substantial non-compete that they had in their contracts, opening all of those laid-off people to access to further employment.
Gwendolyn, is any activity going on in Wisconsin in the area of labor and antitrust?
Well, so one of the things we've been doing that Kate just mentioned is we have signed on to those letters that were sent to the FTC about poaching, anti-poaching. But I can report on our colleagues in Washington State who have received a staggering 200 assurances of discontinuance on those non-compete agreements, specifically targeting low-income workers, especially the ones who would be laid off in this crisis. As Kate just mentioned, you may recall that I think it was in 2018 or 2019 that the state of Washington took Jersey Mike's, a Subway sandwich shop, to court, and then ultimately were able to, Jersey Mike's settled for $150,000 and agreed to stop imposing these non-compete agreements on their employees, which is, I think, a real win for low-income workers.
Yes, remarkable when we think that in antitrust, the covenants not to compete are some of the earliest manifestations of antitrust in the common law. And here we have case after case after case coming out now. Apparently, there's still a little bit for companies and practitioners to learn when it comes to drafting these contracts. Let's go back to mergers for a few minutes. And I've got a question for Paula, and that is the Sprint T-Mobile merger over yet?
So I'll answer that in a second. I need to put a plug in to say non-competes have been illegal in California forever. So you can't enforce them here, full stop. You haven't been able to do it for 50 or 100 years. And so we're joining some of those cases to show our solidarity with our states. But in case anybody's wondering, you absolutely can't enforce them in California. Right, the Sprint T-Mobile merger. So that merger was announced almost 2 years ago, April of 2018. And here we sit on April 10th, 2020, and I can say it is not over. I know everybody thinks it's over, but it's not. Sadly, greatly, I don't know what the answer is. So just to give a brief recap, right, there was about a year of investigation. Then the Federal Communications Commission, the FCC, settled. Then a group of states sued separately without DOJ, and that was one of the first times in modern history that the states have gone completely alone without DOJ or the FTC. We sued in New York. California and New York were leading that. Then the U.S. Department of Justice settled, and then we proceeded to trial. We did not win the trial. The judge ruled against us in mid-February, and so you would think with two federal agencies done and the state's case having lost a trial, it would be done, but it's not, because this case involves wireless assets, spectrum. And what this means is that the public utilities commissions that are all across the country also have jurisdiction depending on their particular rules. And so the California Public Utilities Commission is still working. And they are actually, they have been working with us, with the AG's office. We have worked closely with them for 2 years. After we settled, we put in our, the Attorney General's opinion on the merger. And now we have left it up to them, and they are proceeding. And so the parties announced that they had merged on April 1st, and they were done. You know, they merged, everybody was together, except not California. And they have agreed that they are not merging in California. So they have merged in the rest of the country. I'm not exactly sure what that means, but they're not doing anything in California. And obviously, California is a very large portion of cell phone usage and assets in the country. So the California PUC is scheduled to vote on April 16th, so about a week from now. If they vote at that meeting to allow the merger to go through with certain conditions, which is the proposal that they have on the table, they are far and away the most stringent conditions that any state has received. If they approve those and T-Mobile doesn't fight it, then we will be done. But it's been a full 2 years of work.
Paula, I have to ask, what lessons can we draw about the state of state and federal cooperation in enforcement in the wake of these merger challenges?
Sure. So, I mean, I think I think sometimes people like to point to cases and say, oh, the feds and the state aren't getting along, and somehow this is going to be good for companies or for all you private practitioners, good for your clients. I would say that's not true. And I think you should look at Sprint T-Mobile, and you should look at all the remedies that first the Federal Communications Commission got, and then the US DOJ got. And US DOJ has said in speeches and stuff that they were able to argue and get an even better bargain, get better terms, because the states had sued, right? Because there was a lawsuit outstanding. And they knew that their remedy would be tested in our lawsuit. The parties have said that conditions improved after the states sued. So the federal government got a better deal. The states then, some of them individually settled, they got deals. We lost the lawsuit, and we still settled and got a deal. We got all our fees paid. And still the California PUC is ongoing. So even though the federal government and the states didn't agree on everything, the result was a lot of enforcement. And so I think that one of the lessons you should take away is that if the feds and states aren't getting along, you're likely to see more enforcement rather than less. And when I say not getting along, honestly, I think there were just professional differences about what was appropriate in this case. If you've got some agencies settling, some states settling, some states suing, I like to say any case that goes to trial is sort of a toss-up, because a case that's lopsided one way or the other will settle. So this case didn't settle, and it took 2 years. So it was clearly an area where reasonable minds could differ, and they did differ. And I think that's to the benefit of enforcers across the country, and it's going to make life harder for private companies. If you think us losing that case is going to make your life easier, that's the wrong lesson to learn.
I remember several years ago, I represented the legislature of the state of Alaska, which along with Washington and California sought to challenge the BP Amoco-Arco deal for the very particular effects it would be having on the consumers in those states and the laborers and workers up in Alaska. The Federal Trade Commission in the states ultimately brought and prevailed in the case and got effective relief. I would like to put this one to Stacie and ask Stacie if she is seeing any experiences that might be a favorable sign or encouraging sign of state-federal operation. I noticed, for example, that the U.S. intervened in the Suboxone cases. I don't know if that helped or hurt or was a relatively neutral affair. Is any thought on that from your experience?
And it kind of cut out, I think you said the Suboxone cases?
Yes, exactly.
The feds case in Suboxone is on the criminal side, so it's a little bit different and not, while there's maybe some overlap in some of the conduct that's alleged and that's at issue, it is not directly an involvement in the state's case. But I think that in my experience, we've had a pretty good dialogue with the feds. I know that there's been some ups and downs and some differences in maybe somehow the paperwork is done or practical matter, how things have progressed. But I think anytime that there's a change in administration and you get a shakeup, there are some differences. And so some of that was expected. But here we are several years later, and I feel like hopefully it has, things have leveled out. And I know yesterday, like I said, since early April, we've had a phone call with some of the federal enforcers about wanting to work together on some of these COVID-related issues. I do think that when you have a crisis like this that's national, it's not localized, it's not political, it's affecting everybody pretty equally, that you might see some additional cooperation that will hopefully extend to a lot of the other cases that we work on together. But we've had a lot of positive interactions, including with some local mergers and things that we've had discussions about with them. And so we've had positive experiences.
Speaking of the crisis that has us all in our rooms like now, I would like to examine a little bit more of what we are seeing from the antitrust side, other than the kind of the combination of antitrust and consumer protection and the price gouging cases. But there has been a good bit of talk lately about how the antitrust rules might be tailored a little bit. I'll put it somewhat neutrally there. And perhaps that there is a different approach that the antitrust enforcers should take for collaborative ventures. Paula, what are the thoughts of California on that question?
Well, I should start by saying I'm not speaking for the Attorney General as a whole, or even my office, or even anybody other than me. So I think, it's a difficult question. There have been a lot of efforts to collaborate. I mean, you look at healthcare systems, right? If they are collaborating right now, I don't think we're bringing an antitrust case. I don't think we're going to attack sharing of resources and facilities and critical inputs into the healthcare system right now. I also wanted to point out that we're all at home and we're all using Wi-Fi and we're all using our cell phones. So how are those networks working? Well, for your cell phones, they're collaborating. And folks may have not seen the announcements, but the FCC took some immediate measures to allow the cell phone companies to share all the spectrum. Spectrum is sort of the underlying key resource that makes the networks run. So here we were in this time when we've just spent 2 years, all these agencies looking at this merger and about, well, will Dish enter as a new competitor? And as soon as the virus hit, Dish entered collaborative agreements with the other carriers to share all its spectrum and increase their capacity. And, it kind of upends the remedy that the US DOJ got in some ways, because Dish was supposed to be a new fourth competitor. And what it has done is instantly collaborated with everybody else. And I don't think you saw an antitrust enforcer in the country with an opinion on like that being a bad thing, or like, oh, we're going to rush in and do it. And so try and stop that or something. And so the concern is, I think the concern is not what are the immediate steps that people are taking, because I don't think anybody would argue that it was right for the FCC to allow all the spectrum sharing, because we all need more capacity right now on these networks at almost any cost. The issue is, what if a year from now, those companies are saying, oh, lingering coronavirus, there's still these issues and stuff, and we just want to keep sharing, right? So it's not so much to me the initiation or the immediate actions, it's how do you stop it later? How do you go back to the competitive world, right? How do you get all that spectrum, which is now on all those cell towers deployed across country, back out into the hands of Dish to make a remedy? Or how do you stop the healthcare entities from collaborating nonstop on, all the inputs of critical resources and supply chain and just everything that they're collaborating on right now? So I think the challenge for antitrust is not so much now, but in 6 months or a year from now. And then we're going to have to try and unwind a lot of this, which is going to be hard.
You've given a whole handful of questions that I'm just going to throw to Gwendolyn. Gwendolyn,
Excellent.
how do you handle some of these COVID-related desires to collaborate, and how will you manage some of these challenges that Paula just mentioned about when do you recognize and when do you stop recognizing or start modulating the recognition of the exigent circumstances?
So I think to start with, I think the states will probably take our cue from the US DOJ and FTC, whose recent guidance, expedited guidance for companies that want to collaborate. That review is on a case-by-case basis, and I think that's going to be what it is for us too. So, as Paula was saying, yeah, if a hospital right now needs to offload some patients to, particularly those critical care patients that need ventilators or something, to a hospital that has beds for them, you'd be hard pressed to find that cold-hearted of an antitrust enforcer who says that that's a bad idea. The question will become after the fact, when those two hospitals say, you know what we found during the COVID crisis, that it was so much more efficient if we had those beds all in the same network, and therefore there should be, for example, just one hospital chain in the entire state of Wisconsin. I think how we unwind things like that, I'm trying to just take it one day at a time for that, but thinking about the kinds of problems that we will have in the future and the kinds of arguments we will face, I think we're going to see arguments like that, and I think this is part of an ongoing conversation. I mean, how we will deal with those arguments, it's an iterative process, so I think the answer will probably be something along the lines of, demonstrating that that was actually a pro-competitive benefit, right? It's one thing for a hospital being able to offload some patients if they are at capacity and they can't move them to a different bed, which I think actually already happens in non-COVID times. And it's another thing for example, aggregate manufacturers saying, oh, it's easier if our supply chains are coordinated. I mean, it's kind of apples and oranges, and I think that's why the US DOJ and FTC said that collaboration has to be case by case.
I can certainly understand that. Another aspect of Paula's look into COVID and also the world beyond COVID is the tech cases. And I would like to get some more thoughts from all of you on the tech cases. And Gwendolyn, let me let you kick it off, because I told you I was going to throw a bunch of Paula's questions at you. What do you see in the technical sphere as the states get deeper into some of the tech antitrust issues?
I think on the tech cases, you are going to see these investigations will not lose steam. Whether we have kind of COVID elements in them, I think these tech investigations are really going to be going full steam. Antitrust, particularly the multi-state antitrust community, is already set up kind of, I mean, with the exception of dogs and children, is already set up remotely. I work with all the people on the screen every single day. So we are really used to this remote working, and it's pretty seamless. So I don't think you're going to see these cases lose steam. They're big, complex cases. They're looking at a variety of things in the technology space. The specific things I don't want to get in trouble for saying, so I won't. But that's a really general answer. But I think that's kind of, we won't see that let up because of what's going on.
Do you anticipate cooperation? I'm still with you, Gwendolyn, on federal and state approaches to the tech cases. And I will ask that question before I turn it back to you. I will note in that question that we're not seeing complete cooperation between our federal antitrust agencies on tech cases, as a certain case played out in California showed us. But that's not one for our panel.
Well, so you'll absolutely see cooperation between states and federal enforcers. And it may not be every state cooperating with federal enforcers on every case. I think the tech cases, you'll see that continue. I mean, to say the tech cases is it's such a broad brush. It's like saying the drug cases. There are so many aspects to the tech cases. I mean, the publicly announced Google investigation, the publicly announced Facebook investigation, and all the, I'm going to say million, but it's not quite that many, million little parts of those cases. There are areas for cooperation in all of them. And let me just say, I've been doing this for 15 years. We have a great relationship with the staff level folks at FTC and at USDOJ. And a number of our panelists have said this, but we get along pretty well with all of them. And, we're happy to share our local resources with them, and they're often happy to share their federal resources with us. So I think you'll continue to see cooperation.
Kate, is the district getting involved as well in the tech antitrust? I know the tech industry was an early contributor to a number of the labor antitrust cases, but what with all of the new areas and the new looks into dominance and platforms, my guess is that there are far more issues that might be interesting the district here too.
Yes, the district is certainly active in the tech cases and then the tech investigations currently going on. We're working with the large multi-state coalitions as well as the federal enforcers on those matters. And
if I may, can I get into the task forces generally? And Stacie, Kate, since we left it with you, let me continue with you and ask you, is it a wise idea for someone who's having trouble with the task force and task force leadership to start coming to you and saying, can we do a better deal than I seem to be getting from my interaction with the task force these days?
I mean, Bill, I'm not sure if you're talking about whether we are working in the multi-state context or whether we'd be working on our own. Is that the question?
I'm talking, this is the multi-state context. The multi-state context is a pretty intimidating experience for companies and counsel dealing with a often nationwide initiative. And a question often comes up, what is the best way to handle the initiative? And should I start calling individual participants in the multi-state task forces? And I thought I would start with the district, but I'm going to ask this question of a couple of others and see if we can get a little difference of opinion here.
I mean, certainly I think that the multi-state context has been a very important one for antitrust. It's also very important for consumer and a number of other areas. And the district, especially because it's relatively small, greatly values that rubric in order to help us really leverage resources and be best able to conduct fulsome investigations in these really very broad, very complex cases. And so, we greatly value our relationship with our sister states and would certainly always value working in those contexts. Sometimes there are disagreements among the states. Sometimes there's a mutual decision to move in different directions or for certain states to branch off to litigate certain aspects. But those ties are always very strong among the states, and I think we greatly value them and put a lot of trust and faith in the validity of those and the validity of, the strength in numbers.
My case in the BP Amoco-Arco merger was actually a case in which the states did differ. Alaska had cut a deal that the feds and California and Washington didn't like. But we also see the circumstance where we can have a state decide to go its own way. And I think I saw that in Suboxone, for example, when a state decides that it is not satisfied with the relief that the larger number have reached. Stacie, is there any lesson to be learned in how to manage the multi-state task forces when it comes to getting time to try to find some repose, to get a deal with everybody? What is your recommendation to those of us who deal with task forces on the way to deal with the states in these kinds of cases?
I think primarily there's a distinction that has to be made between the antitrust cases and groups and the consumer-based ones, because the antitrust cases and those investigations, of course, can go into one consolidated case under federal law, and we can all file together in federal court in one case. The consumer cases, can't do that. We have no standing under the FTC Act. We're all working under our state laws in those cases. And so you do end up with some divergent opportunities, I suppose, in those cases, more so than in the antitrust cases. I think I'm of the opinion, I think most of my colleagues in the states are of the opinion that in those antitrust cases, it is very valuable for us to be together and to work together and work collaboratively. And I think typically we do a good job of all kind of singing from the same songbook. But there are differences in our state laws that do sometimes come into play, even in those cases where there may be some value in having different conversations going on, and that's okay. But ultimately, the entire case is unified in those antitrust matters. Consumer side can be a bit different. Those are investigations, and they're unified until they're not. And when states begin to file their own suits, then they become a little bit disparate. And that's what's happened, for instance, in the opioids cases. You have many states that have ongoing litigation within their state, under their state laws. And yet you have a multi-state group that is working towards resolution as a whole. But people are on different timelines. So you might have a trial coming up. There was a trial scheduled in New York back in March that has been continued because of coronavirus. But a lot of people thought, since that's a big state with a lot of negotiating power and a lot of impacted citizens, that maybe that could push towards some global resolution a little faster. But some of the smaller states may not have that same kind of clout when they're coming up and to their trial date, they're on the courthouse steps. It may not move everyone towards a global resolution right at that point. And so then you do see some other side settlements like you had in Oklahoma in that case back last year, where everyone settled except for Johnson & Johnson, and they continued to trial. But so I think that it really, again, is kind of a case-by-case thing. One thing of value when the companies come a call into our offices and they go usually to the top and start with AG level, all I can say is that it is a benefit to our offices in some ways, because it gets our issues that we work on every day and we know inside and out in front of our administration. And you have to remember, we deal with this stuff, and this is where our minds are every day, but our administration has billions of things on their plates. And so sometimes it is easy to have some of these things overlooked that are very important. And that those interactions actually, I think, kind of are helpful within our offices to bring things back to the forefront and to keep some of the focus on what we're doing and the importance of it. And I think it ultimately, because of that, does move the ball forward, usually in most of the healthy investigations that don't end up kind of fractured the way opioids has become. And not to say that it's not still working towards resolution, it's just that there are a lot of different states and different postures with their own litigation, and so that has made things just a little bit different than it normally works.
Paula, let me throw that one to you as well, and I'm going to want to bring the feds back into it, but first let's limit it to the states. And let me ask you the question, state antitrust task force, or we can put it in the consumer protection side, whatever you prefer. California is, last time I checked, one of the larger states in the union. Should parties and lawyers be coming to you and saying this task force is out of control? Can we please try to do some sense in this particular matter?
Well, of course, we can't stop, nor we want to stop people from petitioning their governments, right? So they're going to come anyway. And I actually don't think a lot of people come to California and say the other people are crazy. Can you do something sensible? It's the reverse, right? They go to everybody else on this panel and say, California is wacko. Can you please help us? They want everything. It's like, yeah, we do. Yeah, we want everything. So I think sometimes, California is a bit the 800-pound gorilla in some of these, right? We have 40 million people, and that's a lot. And we have an incredibly diverse state. We cover a lot of geography. We have a very large rural population. People don't think about that. Obviously, we're one of the biggest farming states in the country, which people don't think about. As well as obviously the tech sector and Hollywood and Los Angeles and just incredible urban environments as well. So we have a lot of we have challenges simply to find one answer for California, because the answer for Los Angeles may not be the answer for Central Valley. But we totally believe in working with our states. We think we're stronger together to work with everybody. We like working in multi-states. We like bringing the power of California to bear on issues. I think a lot of companies feel like if they don't get California in the settlement, they're not done and they're not settled. It is very hard to settle a case or to get to a resolution without California, because you're leaving off a very large percentage of the population, and most companies don't want separate rules for California versus other states. Obviously, these are for sort of larger things. For healthcare, hospital mergers, much more local things. Obviously, the states can and do proceed independently. The one thing I'll add is also California has its own antitrust laws, right? And we have our own consumer protection laws and our own fair competition laws. And we're not afraid to enforce those. And we're not afraid to enforce them and have them be different than the federal law. Some of the California state law is different on the drug cases. It is different on some of the standard antitrust issues about how we treat tie-in cases, for instance. And we have a very active legislature, which is continuing to make new laws, which I found out about one. I won't tell you what it is because it's embarrassing. It got enacted last fall, like directly related to some tech company issues, and we didn't know about it, but we found out about it. So we'll be proceeding there. I think companies will always come and try and pick states off. That's just what they do. We expect it. We know about it. We're used to it happening. And generally, as soon as that happens, I pick up the phone and I call all the other people on this call. So if you think you're going to do it in secret, that often doesn't work. States may go their own way, but at the end of the day, this is a repeat player game. I'm going to keep working with all the people in all the other states on a million other issues, and I'm not going to disrupt that relationship just to get some good deal for one particular company.
Can I just fact check you, Bill, before you continue?
Certainly,
you said that there was a state that peeled off on Suboxone. So as the lead attorney on Suboxone, I do need to say that we are 42 states standing strong together. We have not had any peel-offs unless you know something I don't know. And that is litigation.
Gwendolyn, I forgot to tell you.
I think you're thinking of Provigil, which is California. Provigil did have California peel off.
Okay, thank you for that correction, Gwendolyn.
And Louisiana too.
Yes, see?
And Stacie, well, let me ask a question that may be easier to address. Now, I think the question has actually been posed in some litigation right now that Paula may be familiar with, so I won't ask Paula. But Gwendolyn, let me put it to you and ask you whether you think that there is some useful guidance in the idea that the states confine their antitrust enforcement to matters that are largely or solely within their state borders, and that anything that overlaps among the various states should be reserved to the federal agencies. Is that a way to more or less allocate the responsibilities between the states and the feds, in your view?
I think that would completely eviscerate the purpose and intent of Wisconsin's legislature, which created Wisconsin's antitrust laws to protect Wisconsin consumers. So unless we are going to isolationists and Wisconsin consumers don't participate in the international economy and the intra-national economy, I don't think that's going to work. We're not buying dairy from California, let's be real. But we buy the Apple computer that I'm talking to you on, that designed in California, built in China, purchased in Wisconsin, right? Do I have, if U.S. Department of Justice or FTC decide they have other priorities, which they're allowed to do I have no remedy if there's a problem with this? I mean, I don't think that's certainly not what Wisconsin's legislature intended. And though I'm sure that businesses might think that that is more efficient, I think the better approach is this kind of overlapping jurisdiction that we have. I filed an amicus brief, it's probably 10 years ago now, about Wisconsin's Antitrust Act filling in kind of the gaps in federal legislation. And I think that there is a reason why we have this framework, and I think it works very well.
Stacie, you would make a lot of folks in this town happy. Not Kate, but folks at some of the other agencies, if you would disagree with Gwendolyn. Can I get a different point of view from you?
No, no, and actually we've had this come up locally where, and it's a little bit different, but we've had our state antitrust laws interpreted very recently unfavorably to construe our state antitrust laws as only applying to conduct within the borders of Louisiana, which really feels more like a policy decision by, a court that maybe just is tired of some of the cases that were going on. I won't get into that because I could spend an hour telling you about these 6 or 7 antitrust cases that we've brought that have been all over our court system for various reasons that aren't really all dealing with antitrust, more procedural issues. And so in researching that, you get down into interpretations, dormant commerce clause interpretations, and they simply are not valid or applicable. They weren't valid when the Sherman Act was enacted, and they're not valid right now. But you do have some states that are grappling with that and have some what I would consider bad law in the books. But as a practical matter, it just doesn't make sense to confine it that way. I think, especially when most of these issues that we deal with are happening on a global or at least a national front. The mergers even usually are now nationwide, aside from maybe some hospital mergers and some local things that we deal with. Most of what we do does encompass the entire geographic United States. And so those are things that impact our citizens directly. However, and we as the state attorneys general have both the enforcement role that comes from our antitrust laws and from our standing under to pursue things federally as well. But we also have that duty. That's our role in government, as the Attorney General is there to protect its citizens. And so I really think we have to all have be able to play in both arenas and work together that way.
Kate, I hesitate to guess, but given how much of a manufacturing base and agricultural base we have inside the District of Columbia, you might be on board with Gwendolyn and Stacie. Am I right about that?
Absolutely. I think, the District of Columbia is probably the great purchaser. We have a solely urban economy. Like you said, Bill, very little industry, almost no agriculture, labor force that skews very high skill. And so we are large purchasers of everything from internet services to consumer goods. And obviously the district takes its role very seriously in terms of protection of those consumers, both in the consumer protection space and in the antitrust space. And I think that, all the way back when the Sherman Act was started and these state laws began, we really had an idea that there was an importance of enforcement. And so I think there's a plethora of enforcers that really should be in the space. Obviously, the federal enforcers play a very large role. The states play a very large role, but we also have, the jurisprudence has opened this to private attorneys general, where when, for whatever reason, resources or otherwise, the states are not able to deal with it, or the federal enforcers are not able to deal with it, we've opened it up to private individuals. And I think at the end of the day, we want enforcement in this space to make sure that our consumers are as protected as possible. And we want that to come from the appropriate place wherever it can be, based on resources and aptitude.
Well, Paula, I saved you for last on this question, because if I can get all of the voters of California to go in a different direction than Wisconsin, the district, and Louisiana, we still would have a majority for the proposition that we ought to be dividing up the antitrust responsibilities between the states and the feds along the line of, you can handle what happens inside California and the feds will handle everything else. What do you think?
No, it's not. It's not the law. This came up very specifically in the Sprint T-Mobile merger, and the Clayton Act specifically says that it says any individual, any person, any business can bring a case to stop a nationwide merger. And if a single company can bring a case to stop a nationwide merger, then certainly the state attorneys general can bring cases. That case is the Steve's case out of Virginia, by the way, where they were successfully going after a nationwide manufacturer related to doors. But in our merger case, right, the federal government, and it was actually the Solicitor General of the U.S. Solicitor General came in and put a piece in saying that the court should defer to the federal government, which in its wisdom had decided to settle on separate but different terms between the different federal agencies. And the states shouldn't proceed. And, I think that is just wrong on the law. The law says otherwise, and even goes beyond what the states can do, but says any individual person can challenge a merger. I think California believes, I think I can say this on behalf of the whole state, we believe very strongly in the free flow of commerce. Back to an issue at the beginning of this presentation about non-competes, right? That's the free flow of labor, and they've been illegal in California forever. Because you should be able to go wherever, and products should be able to go wherever. And you should have products like your iPhone, which is designed on one infinite loop down at Apple headquarters. and manufactured in China and bought all over the world. And that is the future. And to be protectionist and sort of set up walls around the commerce of individual states, and therefore allowing their state attorneys general to sort of decide what's okay within those boundaries. Generally speaking, that's not how our country works, and I don't think it should work that way. There are certain limits. There are certain things that are illegal in some states and not others. That's always going to be the case. It's always going to be a mix of state and federalism. But I think a fundamental tenet of our capitalist system and our antitrust laws is Commerce Clause, which says goods and products are going to go all over the place. And when that happens, then yeah, the state attorneys general have to protect their citizens, have to be looking broader than their borders.
I think that is a very appropriate last word. And let me simply say that this has been a stimulating and informative panel, even if we couldn't get any fundamental disagreements on some of the contentious issues that are playing out in antitrust and in federal and state enforcement right now. The lesson that I draw from this is the better course for antitrust lawyers is make sure you have a working relationship with the states as well as with the feds, or you are going to regret it when you cannot resolve your problems. And with that, I thank you all on the panel, and we send it back to you, John.
Great. Bill, thank you. Really wonderful panel. Lots of really interesting stuff. Liz Brady, what'd you think? Tell us what some of your takeaways were.
I think my first takeaway is that COVID-19, top of the news, top of the day, has put the spotlight on price gouging and the state's role in particularly the consumer sections of the state AG's offices in enforcing their price gouging laws. And it's good to know that even under less than ideal conditions, the state enforcers are still out there pursuing and protecting their consumers from price gouging.
Yeah, I think that's right. And I think we know how busy the state enforcers have been, because as folks have been wonderful about giving their time to helping us with our program, it has been about squeezing things in, because lots and lots are still going on. I think particularly, as you say, in the consumer protection space in the state AG's offices. Okay, important takeaway. What else, Liz? What other important takeaways did you find?
Another sort of takeaway that came to the forefront was that the states are going to continue to focus on industries that deeply affect the daily lives of the consumers in their states and their state economies, such as healthcare, labor, and of course, technology.
Yeah, and again, it's important, and we've seen a lot of interesting developments, and the states are taking things their own way in many cases. So watch this space. Still lots to learn. Liz, any other important takeaways that you had?
Finally, and maybe the most important takeaway, is that the states aren't going anywhere. Talk that the loss of the T-Mobile Sprint case by the states will dissuade them from pursuing large national mergers or even large national price fixing or market allocations suits in the future because of that defeat could not be further from reality. I certainly think Paula highlighted that in some of her comments on the panel. Additionally, state enforcers are alive and well, and they are an integral part of our federal state system.
And again, I think that on the defense side, ignore the states at your peril. The states are, again, I think are not going anywhere. Liz,
I would agree.
Yeah, I think that's right. Liz, thank you again for coming in and helping us, giving us this context and sharing your thoughts on today's panel. I also want to thank Bill MacLeod, the moderator of the panel, Gwendolyn Cooley, who was the session chair. She helped to put it together and did a lot of work. All the panelists who I know spent a lot of time thinking about these issues and a lot of time on the presentation. So thank you to them. Most importantly, I'd like to thank our members, folks who are watching. Thanks for giving us a chance. Thanks for checking out the virtual spring meeting. Please, until we see you again, be safe and be well.